Hi, David Campanile here, owner of Campanile Law, located in the great state of New Jersey. We do estate planning and we do probate. As always, if you want to talk estate planning with me and schedule your 45-minute strategy session, you can contact me at njestateattorney.com. So a question during the probate process that I get from a lot of clients is, am I personally liable for the person's debts? And the answer to this question is no, but there is an exception. So why aren't you liable? So we'll go through that part first. You're not liable because you never incurred the debts. You never signed off on those debts. So think of that way. You're not in the contract with those companies. Now, since that person is not alive anymore, their estate is in the contract to pay those debts. So how do you pay those debts? Well, you're gathering as the executor all of the account information, all the asset information to basically see, do I have enough money? Do I have a solvent estate or do I have an insolvent estate? If I have a solvent estate, I go back to the probate court. I say, here's all our money. Here's everything we owe. We can pay everyone, everybody's fees, and we're all set and done. Court usually signs off on that and you're on your merry way. Even if you have an insolvent estate, you as the executor are still not going to be personally liable. But here, it's a slightly different process because you're going to go to the court, and New Jersey has a law that basically outlines then the priority of the creditors and who get paid in what order. And you basically go to the court, say, here's all our assets, here's everything we owe, our debts are way higher than our assets. So court, tell us who to pay, tell us in this order how much each person's getting, or when do we hit a pro rata. You're still not on the hook. Now to the exception. You're only going to be liable if you have not conducted the transfers on the debts and paid everything properly. What do I mean by properly? When I say properly, I really mean you didn't pay a certain creditor, you took money out of the estate before you should have. There's some form of impropriety that occurred. Now you're personally liable. But in the state of New Jersey, what a lot wills will have built into it is that you have to usually you don't have to post a bond as the executor. But there are, in other cases, when you have an intestate estate and you become an administrator or an administratrix, you may have to post a bond for a certain percentage, and that bond is basically your insurance policy that, hey, if I mess up, you sue my insurance company, not me. So you're not really on the hook unless you mess up. And that is definitely one of the reasons you want to either consult with an estate planning attorney and probate attorney, or have your estate just hire one. And normally to pay the attorney, that's going to come out of the funds of the assets of the estate as well. That's not going to be the executor's duty to pay that out of pocket. I hope this kind of helped. I know it's something that are on some executors' minds, if they're on the hook or not. So I really hope this helped you guys out. If you know anybody who is an executor that may be struggling with this question, please share this video with them. If you know anyone who is contemplating estate planning, share this video, tell them you were thinking about them. Please like this video, comment. If you're on our Facebook page, please like our Facebook page. If you're on YouTube, please subscribe to our YouTube page. Content coming out all the time. So, as always, my name is David Campanile, located in the great state of New Jersey. We do estate planning and probate. Have a great one.